Good afternoon, colleagues. So we've had to align the allocation of rooms with what is on the online breakout rooms, yeah? So I'll just read out again. For the AI applications in the different sectors in Uganda, we'll move to Royal Palms, which is right opposite this room as you head out. And then the second panel on tech-enabled lawyering will stay right here in the SPEKE ballroom. So anyone interested in tech-enabled lawyering, which will be moderated by Opio Isaac, will stay here. I'll moderate the panel in Royal Palms, so you can feel free to follow me as I get out. Then the third panel, which is going to discuss leveraging technology to optimize processes and improve customer experience, moderated by Among, Arinda, Barbara, will be in Acacia, the room that's right below this floor. So you can follow. Ruth, I think, is on hand to direct you, but it's on the lower floor below this one. Apologies to the ECMIS panel. We had to rejig the program to manage time, and it will be happening at 2 p.m. Same with the Yuli presentation. Thank you. Enjoy the panel discussions.
Yes, a good afternoon to you all, ladies and gentlemen, and I welcome you to this very interesting panel that we are going to have. And I'm pretty sure and very confident that we are going to have a very fruitful and engaging discussion on tech-enabled lawyering, that is pioneering the future of legal practice and the rule of law. We have a very diverse panel that was keenly selected from various sectors, that is from civil society, the academia, private legal practice, and we also have an innovator, tech innovator, a legal tech innovator on the panel. And I'm looking really forward to hearing from them. And I also think you should be excited about this discussion that we are going to have. Without wasting any more time, let me introduce, first of all, before I introduce our panel, I would like to also, first of all, talk about the topic in brief. You know, we are kind of lucky that as lawyers, if you talk about technology in our sector, we are looking at it I would like to look at it in two ways. One, in terms of using AI or using technology to deliver legal services. And then on the other end also, we are legal advisors or counsel. So we need to use technology to make our work easy, but also on the other end, we need to have the skills that are required for this digital era. And I'm pretty sure that almost every lawyer in this room desires to be the lawyer that actually explains the deep tech stuff, beyond throwing words around like artificial intelligence, machine learning, and so on. We need to have lawyers that actually go deep and explain to their clients, to courts of law, to everyone, these terms. Therefore, our discussion today is going to be majorly examining how technology empowers legal professionals to innovate and reinforce the rule of law in the digital era. And for ease of the discussion, I've divided the panelists into two arms. That is one part of the panel is going to examine the future of legal practice in terms of innovation and using technology. And the other part of the panel is going to examine the reinforcement of the rule of law in the digital era. And for the future of legal tech, we are going to look at how lawyers can use technology to ease their work. I've been reading a book. The book is called The Coming Wave. It's by Suleiman Mustafa. And there's an interesting quote that, there's a paragraph that I found interesting. Mustafa says, technology is an internally dangling carrot, constantly promising more, better, easier, and cheaper. And anyone can agree with me on that. We all use technology to make our life easy, to make work easier, and so on. So therefore, we're going to look at how lawyers have adopted technology in their work in ensuring access to justice. We're also going to look at how lawyers can prepare to be part of this wave that is blowing across all sectors of the economy through acquiring the necessary skills. And then lastly, we're also going to look at the regulation of legal practice. We are developing applications and so on, but how are we going to be able to use these applications in line with the current legal framework that regulates the legal profession? And then the other part of the panel, we shall look at the reinforcement of the rule of law. When you talk about technology, most people tend to look at it in terms of the future. But the fact is that technology is already here. We need to understand it right now in its current state, and we need to have it also made in such a way that it respects human rights, democracy, and the rule of law. So we are going to have a member of the panel who is going to look at the reinforcement of the rule of law, how they have, encouraged the rule of law and human rights enforcement, as well as holding digital service providers accountable through their work. And therefore, without wasting time, I would like to introduce our very diverse panel. And allow me, in no particular order, we have 4 panelists, and I'll start with Francis Jimara. Francis Jimara is the head of Africa Law Practice, that is ALP in East Africa. Francis holds an LLM from Cambridge University. He also has a master's in dispute resolution from Pepperdine University. Francis has a Bachelor of Laws from Makerere University and a postgraduate diploma in legal practice. He has been part of the legal profession for a very long time, and he has served as the president of the Uganda Law Society. He has also been a key driver in the establishment of the International Center for Arbitration and Mediation in Kampala. He is a member of the East African Law Society, as well as the Pan-African Lawyers Union. He is also a member of the Rule of Law Committee of the East African Law Society. They say work without play makes, is it Jack or Tom, a dull boy? So Francis doesn't want to be a dull person, and he says that there's life beyond the law. Francis is a marathon runner, and in his free time he runs marathon. He's also the chief convener of the Gulu City Marathon that is held in Gulu City every December. Ladies and gentlemen, a round of applause for Francis Jimara, who is going to be joining us through Zoom. He's not been able to make it. And another member of the panel is Dorothy Mukasa. Dorothy Mukasa is the executive director of Unwanted Witness. Unwanted Witness is one of the most vocal civil society organizations in the African continent and has become the force of human rights in the digital era. Unwanted Witness has shaped discourse on data protection, privacy, surveillance, digital freedoms, and internet governance. Sorry about that. Unwanted Witness, as I've said, is a key organization in shaping the discourse on data protection, privacy, surveillance, internet freedom, and digital freedoms. Dorothy has been a key driving force behind the Privacy Symposium Africa, which is an annual convention that is held annually that convenes data protection practitioners and regulators from all over the world. And then also she founded the Unwanted Witness Privacy Moot Competition East Africa, which is the first of its kind that prioritizes or only examines, that only focuses on data protection and privacy. So she's basically looking at nurturing legal minds that advance digital rights in the world. Ladies and gentlemen, allow me to welcome Dorothy Mukasa. Okay, as she makes her way here, let me introduce, we have also another member of the panel, who is Mr. Wanyama Edrin. Mr. Wanyama Edrin is the legal officer for the Center on International ICT Policy for East Africa, East and Central Africa. That is SPEKE. I think it's, if I use the long word, it's going to confuse more people, but let's just call it SPEKE. SPEKE is an organization that works to ensure and promote effective and inclusive ICT policy and practice for improved governance, livelihoods, and human rights, not only in Uganda, but in the whole of Africa. Mr. Wanyama holds a Master of Laws from Makerere University. From Makerere University, he also has a Master's in Law from the University of Dar es Salaam, Tanzania. And he has a Bachelor of Laws from Makerere University and a postgraduate diploma in legal practice. Mr. Wanyama is a lecturer of law and is currently a lecturer at the Uganda Christian University, teaching cyber law and media law, and is the head of the department. He has written and published contemporary legal and human rights issues, and is also a trainer across various digital rights issues. Ladies and gentlemen, welcome Mr. Wanyama Edrin. And then lastly, lastly we have Mr. Galandi Tony. Mr. Galandi Tony is the managing partner at Diamond Advocates, and he heads the Technology, Innovation, and Intellectual Property Department. He's also the founder of Law Tech Associates and Consult, which is a local tech company behind the legal AI research assistant for lawyers that is called the app. Mr. Galandi has attended and presented at various conferences on AI regulation and legal tech. He has a master's in institutional leadership and management. He has also a postgraduate diploma in legal practice from the Law Development Center and a Bachelor of Laws from Makerere University. He's a member of the Uganda Law Society, the East African Law Society, the Uganda Christian Lawyers Fraternity, the Rotary Club of Kampala, and is also he has been a very important part of this event as one of the main ideas behind it as well as the organizers. Ladies and gentlemen, let us welcome Mr. Tony Galandi as he takes up his seat at the panel. I've been asked, can we push a little bit closer so that we have a more intimate and engaging discussion in maybe 1 minute before we start? Come closer. Yeah, so we are going to start the panel discussion. Yeah, so when you talk about technology, as I said earlier, it has affected all sectors of the economy. And we are all aware of that, including the legal sector that has not survived the technology wave that has swept through various sectors. And because of that, lawyers have found it necessary to innovate or come up with technologies that enable them to access, and that enable them to get clients, that enable clients to access them also, and also do their work for their clients. And for this part of the discussion, I'm going to direct the questions to Mr. Galandi Tony, since he's the innovator brain of the panel, and he's going to represent innovators, legal tech innovators, because he has an app that he uses to deliver services to his clients. So Mr. Tony, what are some of the examples of the innovations that your organization has used to deliver justice to the society or their clients?
Thank you very much, Mr. Pio, Isaac. First of all, you and me appreciate that the trend today in legal practice has changed, and this is the gospel I have been spreading for the last 3-4 years, thanks to a team of dedicated young men who joined me on this journey. We have a young man called Ekisa Austin. We have a young man called Chodrin. These are the guys behind our technologies. Ishiria Uganda, Ishiria Kenya, iLawyer, LexChat. So back to your question, what are these technologies that are shaping the future of legal practice in East Africa? We have one application, it's called the iLawyer. Now the iLawyer works so much like Uber. The difference between the iLawyer and other apps is that it goes through the review process. Now, how does it work? The advocate here is registered with the register of the High Court of Uganda, and at the same time has a record in the Law Council as a record in Uganda Law Society. So what we do is that we upload an advocate of the High Court of Uganda who has a practicing certificate on the application. We enter an agreement with this lawyer with respect to ethics and so on. We verify whether or not this person is actually a practicing certificate, and that is done by the Law Council. We verify with High Court, we verify with the Law Society. And then once this lawyer has been uploaded on the system, and entered into our consents, this lawyer can now be able to activate that application called iLawyer on his phone or his gadget, and can choose to put when to be active and when not to be active. So wherever the lawyer activates active, it means that anybody who has that app will be able to see that I have a lawyer next door. On the other end, the user who has uploaded this application on his or her phone or her gadget is also able to activate and see if there is a lawyer nearby. Now, what is in for the lawyer? What is in for the lawyer is that A, the lawyer is now able to access a client without necessarily moving from where he is. You and me will realize that one of the challenges why we are crying that there are no jobs and the regulatory bodies are constantly producing lawyers, and yet we keep crying that there are no jobs, is because 80% of our populations in East Africa fall under the unlawyered community. Opio, there is a guy in Koboko who wants legal advice. But you know his challenge is that Opio, who works at Diamond Advocates in Kampala, is not accessible. Opio is so bureaucratic. For you to access Opio, you must file in a form for an appointment, you must talk to the PA. Now this app comes in to solve that problem, so that that unlawyered person is able to access a lawyer. Number two, on the other end, apart from accessibility, is providing the solution. We face a number of challenges as clients in accessing justice. I keep giving an example of this beautiful lady whose handsome husband has rented for her an apartment in Kololo. And has told the askari that wherever this one is moving out, you call me. But this lady is undergoing domestic violence in the home. This lady is not a lawyer like you and me. And what is keeping her in that home is one thing. I want to ensure that if I left this home, I have custody of the kids, because that's the only thing I'm hanging on. And she's looking for that solution from a lawyer. So all she wants to hear is one word. If I asked for divorce, if I left this man, can I get custody? But she cannot leave her home. She's under key and lock. She's hanging in there because she's scared. She cannot come to Diamond Advocates because she can't leave home. But this client now has an option A of anonymizing herself and calling that lawyer and say, look, this is a challenge I'm going through. And the lawyer is making money. I'm going to give tentative figures. Let us look at it this way, that maybe this client's call, the initial call, is costing Uganda shillings 10,000 shillings. The first 1 minute. And the next minutes are costing 500 shillings per minute. So if this client made this call, the first 1 minute 10,000 shillings, and talked for 100 minutes, that's another probably 50,000 shillings. So the client is spending 60,000 shillings, and she's getting legal advice. And look at it this way. If this 50,000 shillings, the aggregator who is collecting money on behalf of the firm is taking, and expenses are taking 30, right? And there is a balance of 30,000 shillings. This 30,000 shillings is supposed to go to the lawyer. Now, this lawyer does not necessarily have to leave a home or a coffee shop where she's working. So if you are having 30,000 and this lawyer is only receiving 10 calls in a day, that is 300,000. If we say that on average in the whole month, this lawyer is only going to receive 10 calls in 10 days out of a month, that is 3 million shillings. I can tell you, you have created a job for that lawyer. And that's what we are doing at Diamond Advocates. We are creating solutions. We are creating solutions. So that's one application which we are looking at. And that way you have brought the unlawyered community into the forefront. And that way you stop crying that the lawyers are too many. You stop the gatekeeping. Because all we are doing is gatekeeping. Let us bring this restriction, let us delay. I will tell you, a number of lawyers are not able to be here today. You know why? Because they graduated from the Law Development Center 2 years ago. But the system has curtailed them. They can't join because we are regulating. The lawyers are too many. But these lawyers sold whatever they had from their villages to be able to get this profession. So one of the the applications we are running at Diamond Advocates in conjunction with our tech firm, Ishiria Uganda, is the iLawyer. The other technology which we are running is Ishiria LexChat. Now LexChat, the way it works is that it has been trained on data from Uganda Law Library. And the way it works is that you are able to do research. It's a legal AI research assistant. You are able to do research. You are able to do it's able to draft for you pleadings. It is able to draft for you submissions. And the way it works is that because it has been trained on big data, that's all the cases, say for example, in URI. You'll be able, if you are interested on judgments of Justice Mubiru, for example, you'll be able to run a principle you want. Say for example, you're talking about a principle of fraud in land. Once you type in that principle on fraud on land and you customize it to judgments of Justice Mubiru, what it's going to do is that it is going to run its data on the judgments of Justice Mubiru on simply one principle, fraud on land. It will give you the page. It will give you the citation exactly. It will give you the year. So instead of you having to read big volumes of 20 judgments, in a split second, you have this off the hand. The lawyer of 1980 is not the lawyer who is going to practice today, I promise you. Today, clients are coming to our offices with the drafted digital documents already. He comes with an agreement, it's already drafted. And says, counsel, all I need from you is, can you panel beat this? So what LexChat Ishiria Uganda has done is to now erase the gray area. Why? Because the lawyers are relying on tools that have been customized on data outside Africa. Solutions that are not customized for Africa. So the precedent, if you run some of these AI applications that you find online, is that you are going to end up quoting laws that don't exist or precedents that don't exist. So to clear that gray area, Ishiria Uganda, together with Diamond Advocates, we have come up with that tool, which is going to help you do research, draft pleadings, fine-tune them. One of the challenges you realize, Isaac, is the quality of the pleadings. It's a problem because we now have a lot of dopamine effect in technology. We are more comfortable seeing visuals. That's why when you drop a nude, it trends. Yeah, the James will tell you that he has united us because of the dopamine effect. We want the visuals. Yeah. So this comes into to resolve that area. So ideally, I am glad that after this conversation, we have a slot where me and my team are going to be presenting how these tools work. We are going to be demonstrating how these tools work. We have a tent down there. We have a booth. But we have had the honor and pleasure that after lunch, we are going to be having a presentation and a practical presentation on the search and how these tools work. Thank you very much.
Thank you very much. Thank you very much, Tony, for that wonderful discussion. And I can look forward to, I'm looking really forward to sign up as an iLawyer, probably, and then also use my, draft pleadings and documents using the LexChat. Yeah, so I'll come back to you with another question. Let me first engage Mr. Wanyama. You see, currently we have someone once said that, okay, not someone, I read from somewhere, and they said that technology is an orchestra without a conductor. I hope we all know what an orchestra is. That kind of building where you enter and there is a conductor and people are all singing either uniformly or, uniformly. And by saying that technology is an orchestra without a conductor, I mean anyone can come up with any technology. We have people who have done computer science. Someone can come up with an app that provides legal services without restriction. He will come up with the application, upload it on Google Play Store and the Apple Store, and people will download it. It will draft for people pleadings, it will draft for people documents. Any lawyer can also come up with, an app and so on. So there is no restriction. Even new lawyers can come up with applications that provide financial advice, medical advice. No one is going to stop you and say you need a medical, certificate, or you need to have an a medical background before you do that. So the same dilemma is faced by the legal profession. Anyone can come up and, create an app or anything that can provide legal services. So I'm going to ask Mr. Onyama I'm going to ask him two questions because they are so interrelated and he will answer them at the same time. So we have Mr. Onyama. What regulatory adjustments do you think can be made by the regulators of the legal profession to prepare the legal profession for the AI or tech-driven legal practice? And also, when you make these regulations, how can we balance innovation together with the traditional, we have traditional values of practice that will definitely not go away. So how do we come up with regulations that will balance innovation while respecting our traditional, traditional rules in the Advocates Act and the regulations that will definitely, I have hope, will remain valid in the tech era?
Thank you, sir. First of all, I want to make a few corrections from what my good moderator stated. First, he promoted me at UCU, but I'm not head of department. I have previously been heading media law and policy and cyber law. So I'm not a head of department, but I've been heading those subjects. Secondly, SPEKE stands for Collaboration on International ICT Policy for East and Southern Africa. And SPEKE works towards using ICT as an enabler for improving livelihoods. And SPEKE does this through research and documentation, capacity building of key stakeholders like parliamentarians, lawyers. We've had a series of trainings for lawyers in digital rights engagement and litigation. And that brings me to the aspect of strategic litigation as a niche that we use at SPEKE, specifically on digital rights and from a collaborative angle, where we believe that when we collaborate, we can do much more. And we're a movement builder and a big convener of the annual Forum on Internet Freedoms in Africa, which is slated for Windhoek, Namibia, for this year. So at SPEKE, I work as program manager legal, so that also didn't come out clearly. So in brief response to what the moderator has asked me, I want to start by posing a small question from what he stated, my previous speaker. He spoke about innovation, and he spoke about things that hinder people from being innovative, and also, of course, the good things that Diamond advocates and others are doing, especially as far as enhancing the usage of online systems, including AI to fast track legal practice, drafting of documents, and the like. There was once a man, it could be true, and some of you might be knowing, someone develops an application, and then innovation, it develops an application, and then ferries all England law reports and puts them there for lawyers to have free access. Meanwhile, he has no copyright over those All England law reports. Or someone picks us, the teachers, the lecturers, they pick your notes and publish them or avail them at no cost. And then they go around saying they're the leading innovators, say in the country, legal innovations, that they're doing all that. That places, of course, us at a different dimension and calls for legal ethics compliance and professionalism to ensure that even as we're thinking about innovation and the work we are doing, then we need to be really sensitive and know that there are benchmarks or there are lines beyond which we are not supposed to cross. And then that would bring me to responding to the few questions that he has asked me. So how do we make sure that in the age of AI, that beyond what Diamond Advocates is doing, beyond what so many exhibitors are doing in the hall down there, is within the parameters of what we'd consider to be legal ethics and professionalism. So in my thinking, even as we are taking on technology seriously, which I push for anyway as CPESA, we can amend the rules, for example, of professional conduct. This would, of course, bring in the Law Council, Uganda Law Society, the Law Development Center. You know what is happening. I also teach at the Law Development Center. So some of you have been my friends at LDC with others who are here. So you know that these entities, once they come together, we can actually have proper usage of AI by integrating ethical standards on how we can actually use artificial intelligence to improve legal practice and professionalism, or on how we can actually draft documents and make sure that everything is okay and reflects actually your mind and not the mind of bots and robots that are designed. Recently in Kenya, some lawyers actually stand to be penalized by the courts because they were using AI to develop submissions that they submitted to court, and they had the wrong citations of their cases. So where does it leave the lawyer anyway? Shouldn't the lawyer be regulated? They have to be regulated. Beyond that is, I would also pose to you a question. Right now, the Uganda Law Reform Commission, I have not seen members of the Law Reform Commission around. I didn't even see a booth. I moved all around. The Law Reform Commission revised the laws of Uganda last year. And the new volumes are actually there. But I guarantee you, even if you have Gemini Pro, even if you have ChatGPT Pro, even if you have the best tool right now, and you go and feed in and you want information on the latest laws of Uganda, you will not get the results you want. Do you agree? True. Why? Because the Uganda Law Reform Commission has restricted access to the new revised laws. What will be working in are the old laws, 2011 Computer Misuse Act. Everybody, even if you go to UK, you go where anybody who is sending you an opinion written about Ugandan laws is giving you laws that are way back, not the revised. Amendments not integrated, yeah? So we have a problem there, even as we are pushing, but even our institutions need to address that. But in short, is that these rules have to be amended, and in the amendments, they have also to integrate how actually lawyers can have easy access to some of these documents and instruments, while also paying keen attention to the ethical standards and guidelines to make sure they do not go out of the boundaries, they do not operate outside the scope of the law to give us wrong stuff. As the lecturers, we are facing similar problems with young lawyers who are telling us that they are now Gen Zs, they are now using AI. You go and pick information they have given to you, it's actually AI generated. And now we have tools that detect AI. And some of us don't need the tools. You just have to look at the text and you'll know this is actually picked from somewhere. So our institutions need also to address that. Secondly, clear guidelines and standards for transparency, including rules against bias and overcoming the potential of illegal practice is very key, and that's how we call for regulation. Imagine a world where, as he has mentioned, a client walks in your law firm with a document, yeah? Council, this is my document. Please panel beat it. Who told you to give me instructions on how to panel beat? Come with your challenge and ask me to handle it. But don't come come to me with an already drafted document and you tell me, I have a draft. Please panel beat. And then you end up giving me little money. But beyond that, what I'm trying to bring out is that there's a possibility of illegal practice using AI. This has happened. We have heard of people who have presented themselves as legal gurus. They practice law. They are known in the state house. They are known to be lawyers. They even appear before the courts of justice and present their issues. So imagine in the world of AI or in the advent of AI, it's going to be worse. So where is your position as a lawyer? This is when I would call you that, well, while we are pushing for AI, we need also to make sure that regulation comes out clearly so that we can deal with these errant people who are not lawyers, but they are holding out and wanting to take our positions. Thirdly, the aspect of innovation. I want to speak about responsible innovation and collaboration. This requires that we have in place proper regulatory sandboxes. Sandboxes are usually designed to help people who are entering into the field, innovators, be it health, be it legal, that, well, we are going to operate and regulate ourselves, but we are placing ourselves against a specific regulator who oversees us. For example, if the lawyers come in, Diamond has some applications or innovations that have been developed, then that is when we'd say, yes, we are putting in something in place to help us regulate, self-regulate, and check ourselves, but we agree that we are under the Law Council and it is there to guide us. So those are the three things I want to talk about in terms of why the need to regulate, even in the advent of artificial intelligence, to make sure that there is accountable lawyering, there's transparent lawyering, and that clients are not left either with unanswered questions, and also that as lawyers, as we deal, we do not deceive people, we do not deceive others, that we can actually do what we cannot. And that would mean that we have to bring ourselves within the ambit of the regulators. The other aspect, which would be my second question that I want to respond to, relates to balancing innovation with traditional professional standards while ensuring access to justice and reinforcing the rule of law. This, I want to push it to the regulators and tell them that, well, AI is here. We cannot underlook it. Yes, amidst the challenges I've highlighted just above, we have quite a number of issues that are there, but AI is there, and the only way is to identify ways of how we can best integrate it in legal practice and how to use it responsibly, because it could transform the justice sector. ULI, Uganda Legal Information Institute, puts documents there, and you can actually look for them. You can use AI, as I mentioned, and you'll get the information. But I again have a small concern. He talked of an application which is probably integrated with Uganda Online Law Library, yeah? And one of the biggest concerns we raise about AI is that the potential for it to be overly intrusive. While I called for openness of the laws of Uganda from the Law Reform Commission, there are some innovators who put in effort. They put in money to try and bring something that will help. So how about when applications that are deployed are highly intrusive and do not care about people's intellectual property rights? They do not care about their efforts. So where do you place it? There is need for that as well to be in place. Secondly, disciplinary codes for errant practitioners not exercising due diligence, like the person I mentioned in Kenya. You write your submissions and present them to court. In my year of learning, when I was doing my law degree, I didn't manage to get a second upper. But we discussed about someone who had got an upper class degree at Makere. And this is what, that these guys were sharp, that for them, when it would come to quoting cases, They would quote a case, and I'm told it even went up to the Law Development Center. The person quotes a case which is fictitious and says unreported, yeah, and then submits and doctors information for that particular thing. Then they get the marks and end up getting a first class or a second class degree. So what kind of, I got second, but not the upper, but I'm talking about upper or first class, which you know at Makerere was almost impossible to get such a degree. So where do you leave such people? These errant guys, how do we deal with them? So we have to find ways of coming up with codes that deal with them, punish them, and take disciplinary action against them. And of course, finally, as I conclude on the questions you asked me, that a multifaceted approach to regulation can go miles in ensuring that innovation continues while not interfering with professional and ethical conduct and practice. What I'm trying to say here is that in terms of saying that we are now going innovation, we are going AI, this has to be multifaceted. It has to bring in aspects of standards, professionalism, compliance by all the key stakeholders, especially now us who are talking about the lawyers who are in the house. We have to make sure that we work within those parameters. If AI is to become meaningful to us, let us stop being lazy and keep deploying AI. AI is good. Go there. Someone says you can tailor content. Don't tailor. At least paraphrase and make changes. And also acknowledge the source. But don't just pick content and put for us there. It doesn't make sense. We talked about the dope, is it the dope age? Me, I thought he was going to talk about the daft, yeah? But let's not present ourselves to be that low that even after going to law school, we are doing things that are completely averse or that do not reflect what we should be doing in light of technological developments and changes. I thank you. Back to you, sir.
Thank you very much, Mr. Wanyama, for that very wonderful discussion. And yeah, it is clear that ethics and accountability will still remain very relevant in the digital era or the tech-driven era. So then our last panelist that we have for the day, I'm going to ask Mr. Francis Jimara. Yes, is now on Zoom. So Senior Counsel, I have two questions for you, and hopefully you can summarize them in about 7 minutes, and we can go into a Q&A session. So basically, these questions are basically aimed at looking at, lawyers in terms of users of the tech services, as well as skilling ourselves for, for the upcoming digital era, that is, in terms of client advice and so on. So, Senior Counsel, how can lawyers responsibly and professionally use technology in their work in order to remain relevant in the digital era? That's the first question. And then the other one is, what can we do as lawyers in terms of human resource development and skills for us to keep abreast with the development of technology that we all know moves so fast? Yes, Senior Counsel, over to you.
Thank you so much. Good afternoon, colleagues. I am deeply honored to speak to you this afternoon. I am unfortunately not able to join you in person, and I apologize for that. I am caught up in between critical client commitments. I would like to start by saying one of the things we need to do regarding the first question, how we lawyers can responsibly and professionally use technology to remain relevant, is to first of all begin by acknowledging where we are now. That has to be personal evaluation. Where am I in this emerging reality? Where am I in this era of emerging technologies, in this season of generative data analytics, and the demand for clients for quick and better solutions begins by having a personal evaluation of where you are. Because when you do that, then you begin to understand your responsibility. Unfortunately, the legal profession, sometimes we are resistant to change. We sometimes like to perceive risks and don't attend to them and do everything else to avoid those risks. But when it comes to technology, that can stand in our way. So the first thing I would think that we need to do, and this is something I do a lot, because just this week, a couple of things I've been reflecting on regarding this topic. Our responsibility today, friends, and as far as professionally using technology is concerned, is a call to develop competence. There is what I will term now a competence duty. You know, the International Bar Association has published some principles that now require us to stay competent, including, you know, being tech literate. And in terms of this tech literacy, we are not meaning go to class and learn computer engineering. No, we are not meaning that you should be able to understand all the algorithms that make up many of these platforms. No, we are just saying that just like you don't have to be a very good mechanic to drive a car very well, you don't need to understand all the components of the engine to be a good driver. I submit that in terms of technology, we need at least what you call essential skills. And I'm guided by the wisdom of Master of the Rolls in the UK, Sir Geoffrey Voss, who said in 2022 that we are living in a season of significant developments, and they will require us lawyers to have some familiarity with technology such as blockchain, such as smart legal contracts, and crypto assets. Now, I understand him to say familiarity is just a basic understanding, not very deep to create these assets. If you can't do that, like my friends in Diamond are doing, the better. But for some of us, we will just need to develop some level of competence, and they can be built around 3 technological pillars. One of which I see is the ability to understand basically what generative AI is and the reasoning models. I think you need to be in a place where you are able to draft persuasive documents faster, you are able to do legal research faster with depth to avoid the mistakes that my friend was commenting on earlier, but also you must be able to verify for accuracy. Now, I think there's going to be a time when your professional standards are going to be judged not by how much you download from AI, but by how much you improve on information that is widely published in AI. For instance, if you draft a contract today, fair enough, it is in AI, and it will give you a fair contract today on something as basic as sale of my motor vehicle. But the lawyer of tomorrow will be required to move beyond that draft of a contract to basically create an original contract, but using AI as the basic. And it will be very punitive for you to give a client less quality work and for AI to do so with more superiority. That, in my view, in future is going to attract some professional sanctions. So the duty now for all of us is to be technologically competent and be able to do that. But also, we cannot afford to be technologically illiterate. It's no longer acceptable, especially when you are required to be efficient. Today, a client will draft a contract on sale of something will actually get it from AI. Now, you cannot, in this era and time, tell a contract that I'll give you that contract next week. So in terms of efficiency, we are required to be more efficient because the tools then are available. First thing I encountered this when I was advising a client on a transaction with their Dubai partners. So what the client did was to get the contract that had been given by the Dubai partners and sat down with the family. They ran it through AI, and in that evening, it was a topic for discussion on their dinner table. They basically went through the contract and understood the key elements. They were meeting me in the morning. Now that was very interesting because the first thing they say, we have gone through AI. These are the issues that we see, 1, 2, 3, 4, 5, 6. Now, of course, with experience and the ability to guide them, I was able to advise them competently. But the point I learned that day from that transaction, that you can no longer go to your meetings unprepared. The client today is more sophisticated. He will run something by AI. And if you show up in a manner that is lackluster, it will be very evident. So friends, let's make technology competence part of our professional identity and not a side skill. Now, on the second bit of the question, responsible use, I want to say that luckily for us, we are in a good place. I want to say that what technology is doing is giving us new opportunities, but the core principles are going to remain the same. And that's why I'm part of the school of thought that says that AI and these emerging technologies are not going to run us out of business. They are going to make a good lawyer much better, and a better lawyer will become amongst the best. But then they will also make those who are incapable of getting into the times to look worse. Because what the technologies are going to do are giving us new opportunities to be better. But the core principles of practice of law, such as maintaining clients' trust, ensuring data is fairly and transparently used, will remain unchanged. So we will be having a big role to play as lawyers in responsible use of technologies, keeping confidentiality, learning how encryption, and ensuring that we understand how platforms have to be secured and how they are breached, and to advise our clients when they are breached, and the remedies can only increase. We are also going to be able to have work originate around checking AI outputs to be sure that hallucinations and factual mistakes are avoided. But we are also going to be able to help. Privacy has just come out of the woods. You saw the Google decision. Following privacy laws and handling client data ethically is going to be part of the emerging work that comes out. So on the first question, I want to submit that yes, there's a call for more responsibility. There's a call for us to be more technologically competent, but also we are the ones to guide more responsible use of the new technologies. Now, you asked me, the second question was, what can lawyers do in terms of human resources and skills to keep abreast with development of technology? Let me begin by saying that one of the things that we need to do, friends, is that we cannot afford to be laid back in this season. We need to think about how we build competences within the teams we have. Number one, to monitor emerging trends. I mean, just listening to what Diamond is showcasing, what the other lady from Kenya was presenting earlier on in the main plenary, it just shows you that one of the best things to do is to monitor trends very, very deeply. And I mean, law firms must begin to bring young people, begin to get critical staff. In that room, there's one of our staff, one of my colleagues called Edmond Babalanda. We thought at ALP long time ago that we needed to, bring in the skills. You needed to get young people to get spaces. Skills and human resource development for law firms is a non-negotiable. Now, Eddie Babalanda came in and we appointed him our AI champion at ALP. So he's pioneering, putting together ALP policies in our law firms, but also leading a conversation with other stakeholders to enable a very facilitative environment for these new technologies. So the point I'm making is you need to have a team that watches the trends. And in watching the trends, there are three things that we need to look at. In fact, one of the books written, I like to follow Paul Caddy and David Jackson. They wrote a book, Legal Practice in the Digital Age, which I recommend. It's a must-have in any law firm that wants to understand the business of new technology. They basically say in the next 10 years, and they wrote this in 2023, they said, let's watch out for these three trends. One, change. Let's prepare for change because change itself is evolving in terms of speed, in terms of complexity, and in terms of scale. So we need to be a team that prepares for change. How do you prepare for change in the law firms, in the legal practice, is something that we need to be concerned about. The second one is data boost. Let's be able to understand how the AI-driven data revolution is going to impact on legal practice. We need to be able to develop skills that identify data, analyze data, and deliver insights to clients. And I think today's client, friends, is paying for value. The subjects we learned from LDC are no longer able to earn us the income we want. Nobody is paying you for a land transaction. Nobody is out. If I was in the room, I was going to ask everyone in the room, how many of you have incorporated the company and you have been paid more than 1.5 million shillings? I would get very few hands. And even then, if a client discovers now that you charge them 1.5 for incorporating a client, they will think that you rip them off and probably they will not return. So URSB is automating all its service delivery. Now, it is easier to blame them for doing that, but the fact is they also have clients who want them to do that. So what we studied in LDC will not take us to the Canaan of technology. We need to be thinking about data, how we analyze data, how we deliver insights to clients using data, and that, for me, is going to be a differentiator between the ordinary law firms and the extraordinary law firms. The third point that they point is, how do we utilize the hybrid era? Those days we needed, before COVID, big offices. You needed big offices. You needed, and in the olden days, yes, people used to jump onto a taxi from Boyogerere to come to the middle of town when they don't know any lawyer. So they probably would end up having legal services from Katenda and Sempebwa, and that partly explains why law firms used to be located on Kampala Road, Jinja Road, and in all those places. Because then if somebody drops off a taxi, then they go to the law firm. Is that the case now? No. The hybrid era is requiring us to move with our clients. Clients today are online. Not many of them are coming to offices. Are we prepared to shift our engagement with clients to online? So three things we need to pay attention when we are looking for trends. One, again, change. Two is we need to understand data boost and how that impacts the legal profession. Three, we need to understand the hybrid era and what that means for our businesses. The second thing, and then I'll wrap up the second question you asked, is also how to get more skills in terms of collaborating to innovate. Today, you are not going to have many law firms working in silos. Today at ALP, we have a multidisciplinary team. In fact, in some law firms now, the lawyers are becoming fewer and other professions are increasing out of Uganda. We have to understand today that lawyers will work with all kinds of people in the future. The traditional lawyer-centered approach is shifting to multidisciplinary teams. So in terms of skills, how do you work with multidisciplinary teams is going to be very, very essential. So let us also think about the third thing, lastly, is the mindset shift to a learning mindset. Friends, they say good education is about learning, it's about unlearning and relearning. And to do that, we need to think about a mindset shift. A mindset shift that makes us not to loathe technology, but to embrace it as a way of accepting that the future has arrived, but how best do we harness it? Now, of course, mindset requires a lot of things. We need to think about how we are going to develop essential skills. We are also going to think about training options, but also we are going to unpack some of our institutional setup. How is the ULS set up today? Are they helping us to do minimum, to comply to the minimum tech competence required for a professional lawyer today? We need to tailor-make our professional development programs to make us more savvy as far as technology is concerned. But also law firms, please have budgets for technology. Have budgets for tech training, also have budgets to form partnerships between your young lawyers and innovation hubs. But also for the regulators, let's be guided by the developments happening in the US. We have some examples. The American Bar Association has issued guidelines. We have the IBA. So in conclusion, let me say this, that we need to accept that change is here, but most importantly, we need to manage change and thrive on change. Let's be guided by some of the examples of key industries that did not take change very serious. I leave you with an example of Skype. Before COVID, all of you remember there was Skype. They went to sleep. COVID started, Zoom came. Recently, they announced they were closing. Let us not be like Skype. Let us innovate. Let us choose to change. Let us have cultural change. Let us learn more, but let's be technologically competent, not only to serve our clients, but also to promote the rule of law using technology. Thank you.
Yes, thank you very much for that deep discussion, Senior Counsel. And yes, as you have heard, it's now totally unacceptable to be technologically illiterate, because our expectations, the client's expectations have also risen highly. And with that, I would like to open up the floor for any questions or comments from the members who have been listening to us, both online and within the room. Can someone help us deliver a microphone to this side? Please, whether direct the question to a particular panelist, or you can just throw it at them and any one of them can answer.
Thank you so much. I'm Higenyi Simon from AILEX. I would like to address this question to Mr. Wanyama. We very well know that currently the reason why there is a great debate about data is because the people who are creating AI tools are the ones who are using it unethically. However, one thing I've gotten to realize is that law firms, especially whoever is using an AI and is a lawyer, they're literally feeding these AI tools with either information or documents that are containing people's personal data, or rather violating the right to confidentiality and privacy. So heading forward, what strategies should we consider to ensure that at least though people are using the data, they do not violate the right to data privacy and security in the circumstances? Because right now we talk about it. That's because it's a big debate right now. But in the future, it's going to become a common norm where literally everyone uses people's data because, well, we want to produce very good documents and submissions, drafts, and we need all that data to be fed to the AI. My second question would go to the general panelists. It is actually what Councillor Wanyama also spoke about. He said AI tools are being used to assess whether students or people are using AI. Then the question goes, how can we guarantee the authenticity of these AI tools that assess whether someone has used an AI tool to do their assignment? Because I think it was last month, whereby I think it was students of either Cambridge or Harvard. They were an AI tool was used to assess whether they had used an AI to generate their work, only for the university or institute to realize that actually the system had wrongfully flagged their work as AI generated, yet it was not. So how are we going to assess the authenticity of these tools themselves to ensure that people do not become victims of these same systems that assess whether they have used AI tools or not? Thank you.
Responsible use of AI.
Thank you. Any other question?
Yeah.
Thank you very much. Thank you very much, the panelists. My name is Maria Elizabeth Nampima, and my one question is, what role can early career lawyers play in shaping tech policy before it reaches to government or regulatory bodies like the Law Council? Like, where do young lawyers start from, and how can we go about that? Thank you.
Thank you, Maria. Any other question?
Thank you, Right Honorable Speaker.
Thank you. Good afternoon, everybody. I'm Fatuma Kakoza. I have a question and a comment. My question goes to Councillor Tony from Diamond Advocates. With the iLaw and Lex Chat, would I be right if I presume that it's a solution to this not so pleasant habit of clients fleecing legal advice from the phone, free legal advice over phone conversations? Then I have a comment for Councillor Jimara. As we embrace the digital transformation, because he says it is something everybody should embrace, we should also put in consideration the fact that some state players, like I'll give an example of the Administrator General's office, are not as keen to embrace that digital transformation. So even when you have embraced it, your progress is laid back. I'll give an example. I don't know whether it's the experience of other advocates. The Administrator General's office does not even have the courtesy to call the advocate and tell you your file has been allocated. This kind of systems are so porous to corruption. So as we think about the fact that we have to embrace the digital transformation, we need to put in consideration some very critical players that we need in the course of our work. Thank you.
Thank you so much, Fatuma. Over to you, the panelists.
We are going in the order of the questions, right? So we shall start with Chris. He directed these questions to Mr. Wanyama.
Thank you very much. Sir, for the question. I want to state categorically from the start, as mentioned much earlier, that, well, the usage of technology is quite multifaceted. Too many things that we are merged in, too many things to deal with. And of course, the subject of data protection is very important and very key. And in that, sometimes we are confronted with debates as to what actually is readily available information or public information for usage, and what actually constitutes private information that should not just be used And even when we read the Data Protection and Privacy Act, it also has quite a number of complex issues with a lot of exemptions to what they consider to be private data and what is not, especially the balance of national security and rights of others vis-a-vis what information that can be readily available, such as names. But also it brings into sharp contrast our usual issues of the right to be forgotten, which is something very key. That is when, for example, the information you're raising becomes quite contentious when we are dealing with information that has been used and met the purpose, but still continues to exist on platforms where it shouldn't, in violation of the right to be forgotten. For about 8 years, I taught law at Kampala International University. But later, I quit my position at Kampala International University. But I noticed on their website, or even up now, if you do a quick Google search about me, one is that they refer to me as a she. That is one. Number two is that they say I am a lecturer at Kampala International University, yet it's now over 2 years since I actually quit. And the truth that they're riding on my name as one of the lecturers in the university, but I quit. So that brings in the issues you're talking about, the right to be forgotten. If my data has served the purpose, change it to reflect history. He was with us, he left, he's no longer with us. But of course, the other aspect of she is, I think, the name of Adrian. Even when I was graduating at Makerere, they put me in the category of ladies, MS Adrian, yeah? Instead of Mr. That one I would have no major issue, because I know myself, of course, I am straight, but I know the name confuses. But in short is that there is a distinction between what we call public information that should be readily and easily available for use by individuals, and then we have information that should actually be considered to be private. But also, finally, we have issues that also come into contrast, what we call the overly intrusive character and nature of artificial intelligence. That artificial intelligence has no human mind. It depends on what is fed into it. So in most times, AI is very intrusive. It goes excessively into people's privacy. And since we do not develop, most times, Africa, we depend on tools that are developed there, and then they are made available for use, and we actually just put them to the usage that we need. In short, is that has to be struck in terms of the balance. When do you use somebody's name? And it also calls for awareness. For example, you as the lawyers, I had Counsel Muchibi, was it yesterday? I think he has walked out. Oh, he was talking about, I think this morning, he was talking about confidentiality between the client and the lawyer. That you're using video conferencing, someone is in Luzira and communicating here, and the whole right of confidentiality or the principle or the role of the lawyer has been eroded simply because we are depending on technology. So too many things in contrast so that I can say, but we have to, as lawyers, we have to exercise due diligence to ensure that in our dealings, or even when you do a research, make sure that you're aware. That is what Counsel Jimara is talking about. Don't allow to be left behind. Adapt and measure up to the standards and make sure that you know what to weed out and what to go with. Otherwise, you'll be found in those gallons of someone who has violated or infringed on people's privacy. And finally, something that I wanted to comment, I think it was a lady called Nampima, she shaping tech policies before legislation. There are usually opportunities. The only problem we have in this country is that most times some of the policies, unless some noise has been made around them, we never get to know, and we just hear maybe a law has been passed in Parliament on this particular issue. But when issues are actually contentious is when they come up and everybody seems to be interested in those particular issues. So we can always target that. There's an organization called Parliament Watch. For example, if it is something in Parliament, you can always be on the lookout to see what they are putting on their site. They're always proactive. You can always check out to make sure that at least you input. Usually public input is available at Parliament. You can go and present your comments. Currently, we have a bill on turning the Law Development Center into an examination center. I think so many of you have seen it, and I think it's up. This is the time when you start to prepare your commentaries such that you can present them to make sure. So for you, the young lawyer, if you feel you're going to be so much affected, so comb the bill, look at it, raise your issues, and see how you can actually present them to ensure that they're actually presented. That is, of course, outside tech, but it has tech issues as well. For technology, be on the lookout. For us, we are available to support. CPESA does a lot of work around that, policy analysis, bills, and the like. We also engage with parliamentarians. You can always look up for us and see how we can support in the processes. Data Protection Office is there, and other agencies are available. We can always talk to them and see how they help. Thank you very much.
Yes, thank you very much, Mr. Edwin. The next, maybe Tony, you can answer in a minute, and we conclude. There's also a question from the online platform. A lady called Margaret Nabukera asks if iLawyer is available to all lawyers, only restricted to Diamond advocates. So you can answer in a minute. And we conclude.
Thank you very much. I think we'll start with Hajat. Will iLawyer solve the issue of clients getting advice without paying for it? I'm sure she's conversant of a Ugandan proverb called counsel, a quick one. We raised that parable at Diamond Advocates. We don't have a quick one. We say, could you call us through the app? So yes, that is going to bring the unlawyered community into the lawyered community. The next question was, is this a preserve of only lawyers at Diamond Advocates? The answer is yes and no. For now, in line with ensuring that we adhere to ethics, which is really very, very key because we are dealing with data. We are right now, first of all, piloting it as a firm, but we are very positive that in the next 1 week or so, we should be able to roll it out to public. We are still collecting all these issues so that by the time it is up for the public to join in, it is fit and proper for purpose. Thank you.
Yes, thank you very much, Tony. So I would like to give maybe a minute to each of the panelists to give us the concluding remarks. We'll start with Mr. Wanyama.
Again, okay. Well, thank you very much, sir, and thanks everybody for taking part. As part of my concluding remarks, I just want to emphasize that one, from the topic at hand or what we've discussed, is that one, AI is inevitable. We cannot stand up against it. We just have to embrace it, but have to find ways of working within it legally, ethically, and within the established professional standards. That is one. Secondly, is that it's a call to the regulators, the Law Council, Uganda Law Society, Law Development Center, and other agencies that directly integrate or put effort into how the legal profession operates, that we come up with clear guidelines, like Counsel Francis Jimara emphasized, that there's need for clear guidelines to set clear standards on how lawyers can actually rightfully, but also responsibly make use of artificial intelligence to make the legal profession much better, and better at that, not better at forging or coming up with content, but better at making sure that I could not say, not humanizing, but really how to make use of AI to come up with clear and compliant kind of text or documents or information that feeds into what is acceptable for the legal profession. Thank you.
Thank you very much. Mr. Tony, give us your concluding remarks in a minute.
Thank you very much. First of all, we must appreciate that AI is here to stay. And we should, as lawyers, come at the forefront of this discussion, and I'm glad this is moving in the right direction. AI is going to change the big firm syndrome. Now, the underdogs are going to play at the same level with the big firms. And this is how it's going to work. Previously, I was in New York, I think 3 months ago, and previously they had 500 lawyers, Lex and Park. And what they would do is that if you send in a contract, they would split it. Those guys in intellectual property are handling a part, the guys in warranties are handling a part, and in 10, 20, 40 minutes, the contract is bound and ready. So they needed 500 lawyers. Now, they don't need those lawyers. They need an AI, so jobs are being lost. Number two, I think at our level, we are still so much at the basics. If we are still conversing and our conversation is about alchemists, that's like knowing ABCD. Tomorrow's lawyer is going to be that lawyer that is going to speak Python like our local language, Kaja, Chechiriwo, Chechigenda Maso. That is where we are going. And if we don't adapt, we are going to be like the secretaries who ended on the typewriters, and when the computers came, they were no more. Isaac, for me, I would recommend countries in the West adopted this almost 25 years ago. When you look at a book by Sanskrit, a professor of law, he predicted this 25 years ago. When you look at a book by Goodmark, Mark Goodman, his Future Crimes, he predicted this 10 years ago and said the crimes you and me are going to be dealing with are going to be crimes related to Internet of Things. I was in Silicon Valley a few months ago, and when I checked into a room, and they were telling me, no, you can use Alexa. And I'm like, what's Alexa? It says, no, you tell it, I'm depressed. And it automatically plays for you some nice music. You tell it, okay, Alexa, what's the day like? Can we chat? So the kind of crimes you're going to be dealing with in the next conversation are going to be crimes related to Internet of Things. Somebody suing because he told Alexa to switch on the fridge and Alexa never switched on the fridge. Somebody suing because he told Alexa to play romantic music when he was having sex and she decided to play reggae. So those are the things you are going to be dealing with. And we must be mentally prepared for that, and the journey starts now. I would talk about this until morning, but I can say that, Isaac, my parting moment is that the journey has started, and as young lawyers, let us embrace this. And to my senior colleagues like Francis Gimara, who happens to be a friend, it is time for the children to dance, to drum, and we dance. In my village in Bodaka, they say on a rainy day, the young ones drum and the elders dance. So it's a time for reverse mentorship. It's a time to listen to the young lawyer and not to mentor the young lawyer, because the law now is for the young lawyer. So let us create budgets, let us embrace teams that are tech savvy, and let us sponsor these young men. We have Diamond Advocates, we have set up a full office for the technology department. And we're not only taking lawyers, we are saying we are also bringing these tech savvy innovators, because you, the lawyer, you may not have the time to do this, but you need to embrace it, and you need to create budget for it if you are going to be competitive. Because the clients are coming when they are already full with this information. Maybe as I close this down, I'll give you a very funny story. When I was in Francisco, I was seated to a guy, very senior top lawyer, Gilbert Kerry, and he has practiced for 50 years, top dog, in San Francisco. And a client had subjected his legal opinion to AI, and it had returned a confidence level of 40%. And the discussion they were having was, counsel, why do you charge? I cannot pay you this money because AI tells me the confidence level of your legal opinion is 40%. Justify why I should give you 100%. I'm only willing to give 40% of the confidence level, unless you can challenge this position. So that's where we're going. And the better we start, the earlier the better. Thank you very much, Isaac. I hope I've been able to...
thank you very much, Tony, for that wonderful concluding remark. And I would now like to ask to hear from Senior Counsel Francis Gimara in 1 minute, some concluding remarks from you on the topic.
Two questions, but very briefly, there's a very good question on what we can do to advance tech policies and how we can occupy those spaces. I would like to say that the Uganda Law Society is a very influential organization. I say that with a lot of respect, having led that society. A lot of what we can do to shape policy, shape conversation, belongs to us. The ball is in our courts. So how do we do that? Many years ago, we created clusters. The need for clusters was that like-minded people would come together and work with government to shape policies, to put into place things we want to see. Please, let us understand that that responsibility is ours. We can influence laws, we can influence policies. Never underestimate the power of Uganda Law Society to cause change in anything they want to do, and if they unite together. So the means is us. Let's organize ourselves and let's influence policies. My good friend Fatuma asked me about state players not keen to embrace digital transformation. I agree with you, but they will never do that. A lot of the time, it is the private sector which initiates change, and government normally follows. What we can do then is to continue, again, engaging them on how we need that change led, and demanding that they adopt digital transformation and digital digitization of services. That's a demand we can make based on the national vision, based on what the Minister of ICT has projected. So as a law society, let us go to them and require them to digitize. That's a demand that is legitimate today, and to demonstrate to them that we can no longer do business as usual. It's a leadership question, and leadership, I like the definition of John Maxwell, is that you influence things. It does not matter whether you have a position or not. You seated in that room can lead us to influence the adoption of digitization by a government entity. How? By coming out to tell us with a blueprint and borrowing the umbrella of law society to engage the government entities. I'm sure the council will be very blessed to help connect you to those spaces to influence policies. My parting shot is, again, to underscore that we need to incorporate technology, learning into our personal learning objectives, into the law firm learning objectives, and also make it part of our strategic plan. It can no longer be something that we put as a footnote to our strategies. It has to be one of our strategies. The future of lawyering, somebody once said, isn't man versus machine, but it's it's a man with machine versus the justice gap. And that's what Tony has been saying. most of this morning. There's a justice gap. How do we then use machine or technology to deal with justice gaps? Now, that is going to open up for everyone. Tony, you indulged me in an African proverb. Let me indulge you in one as part of my parting shots, that a kid or a son or a young lady who knows how to wash their hands will always eat with elders. Now, the young lawyers, if you know how to wash your hands, you have the skills. This is the moment for you to eat with elders, to be recognized, to be top-notch, to make some money out of these skills. So it is not that the older lawyers are standing in your way. What we are seeing is that you have a platform. Come and lead. Come seize the space and lead us, because you are more agile, you are more adaptive. And in so doing, we all remember, because I struggle, I also have some young lawyers in my office. I was teasing one this morning who was trying to write minutes using notes. I said, nowadays you don't need to write minutes. There are tools that are available to work efficiently. Please adopt them. So the point here, friends, if there's one thing to take away is this, that emerging technologies won't replace lawyers soon, but those who don't adopt and understand technology will be replaced by those who do. Please mark that. Those who don't adopt and understand technology will be replaced by those who do. Thank you so much.
Yes, thank you very much, Senior Counsel, for those remarks. And ladies and gentlemen, thank you very much we thank our panelists, first of all, for taking off time from their busy schedules to be part of this panel and the festival altogether. And also, I would like to thank the audience that is both online and physically here with us. It has been quite an engaging discussion, and yeah, it comes to the end, but of course the discussions will continue beyond this. Thank you very much. And I hand you over to the MC.
All right, thank you so much, our dear panelists. We appreciate you. A round of applause. This is very grateful. We are very grateful, and we appreciate you, for the Bible says in Matthew 5:16 that may your light so shine that the world may see the good things you do and praise your Father in heaven. Indeed, we are grateful that you've shared your brightness with us, and may God reward you. Keep sharing your burning candles with the rest of us till the end of this festival. And on that note, I would like to invite Senior Council Member, Western Region, Sam Mohumuza, and also Council Member, Northern Region, Mr. Egaru Emmanuel Omiat, to hand over our token of appreciation from the Radical New Bar. And I think Council Member, Northern Region, will take to Senior Counsel Francis Jimara his token of appreciation to his office next week. Thank you so much. Please come over.
I think we may need to stand up.
Mr. Moderator, sir, please come over. Thank you so much. We are grateful. It's now time for lunch. Please, you can meet at Sunset Restaurant and for further networking. May God bless you.